Hi, I'm Celeste Whitmore, and if this were just another case file, I would begin with dates, documents, and a clear statement of claims. But this isn't just a case. This is my family, my grandfather, and a story that doesn't begin in a courtroom, even though that's where it nearly tore everything apart. It begins long before the legal language, before the allegations, before the moment someone decided that truth could be rewritten if it was inconvenient enough. I'm an estate attorney in Michigan. For 14 years, I've helped families navigate loss, interpret intentions, and when necessary, defend what the dead left behind. I know how wills work, I know how disputes unfold, and I know, perhaps better than most, how quickly grief can turn into something sharper, something that looks like justice, but feels a lot more like accusation. That's why when my own name appeared in a lawsuit attached to words like undue influence and forgery, it didn't feel like entering unfamiliar territory. It felt like stepping into a version of my own worst professional nightmare, only this time, I wasn't the lawyer guiding someone else through it. I was the one on trial. The story was framed, at least on the surface, like many others. You might hear in a true crime segment, a wealthy elderly man, a contested will, a family divided by money and memory, and a single question hanging over everything: what really happened before he died? My grandfather Ezra James Whitmore had built a life defined by discipline and quiet precision, and when he passed, he left behind not just property, but decisions. Decisions that would be scrutinized, challenged, and, in the eyes of some, deemed impossible to accept. Because in their version of events, the distribution of his estate didn't make sense, unless something had gone wrong. Unless someone, me, had interfered. The lawsuit came 4 months after the funeral, but if I'm honest, the tension existed long before that. It was subtle at first, the kind of thing you only recognize in hindsight. A question asked in the wrong tone, a pause that lasted a little too long, a conversation that circled back to the same point without ever naming it directly. By the time the legal complaint was filed accusing me of manipulating my grandfather and fabricating his will, the narrative had already taken shape. Not publicly, not formally, but within the quiet assumptions people carry when reality doesn't align with expectation. And once that narrative exists, it has a way of growing, of filling in its own gaps, of turning uncertainty into suspicion. What made it worse, what made it truly disorienting, was that I understood exactly how the story could be told in a way that made me look guilty. I knew the legal standards. I knew the arguments. I could practically hear the opening statements before they were spoken. An estate attorney, a granddaughter, a man in his 80s, valuable assets, access, opportunity, motive. It was all there, neatly arranged, waiting to be interpreted in the most damaging way possible. And somewhere between those facts and the truth, there was a gap wide enough for doubt to settle in. But here's the thing about stories like this, the ones that unfold in courtrooms and linger in people's minds long after the verdict is delivered. They are never just about the law. They are about belief, about who people think you are when everything familiar is stripped away, about whether intention can survive scrutiny and whether truth can hold its shape when examined from every angle. My grandfather's will became evidence. His signature became a question. And my relationship with him, something that had always felt steady, unspoken, understood, was suddenly recast as something suspicious, something transactional, something that needed to be explained. So if you're expecting a simple narrative, something clean and resolved, this isn't that. This is a story about what happens when certainty breaks down, when family becomes opposition, and when the person you've spent your life becoming is reduced to a set of allegations printed on legal paper. It's about a will, yes, but more than that, it's about the distance between what actually happened and what people are willing to believe happened when the truth doesn't give them what they expected. And somewhere in that distance is where everything changed. My grandfather, Ezra James Whitmore, was not the kind of man people immediately understood, and he certainly wasn't the kind of man who explained himself for the sake of being understood. He was born in 1938 inches Meridian, Mississippi, into a world that did not offer him much in the way of certainty, and from the beginning, his life followed a pattern that would define everything he became: observe carefully, move deliberately, and never waste energy on what could not be controlled. At 19, with little more than $40 in his pocket and a Greyhound ticket in his hand, he left Mississippi for Detroit, not because he had a detailed plan, but because he understood something simple and essential: that staying where he was would not take him where he needed to go. Detroit at the time was a city of industry and motion, a place where work was hard but available, and for 6 years he worked on the line at Ford, learning not just the mechanics of labor, but the rhythms of systems. The way efficiency was built, the way small repeated actions could accumulate into something substantial over time. He didn't speak much about those years, but when he did, it was never with nostalgia. It was always with precision, as if he were describing a set of conditions that had shaped him, rather than a story that needed to be told. From the factory floor he moved into skilled trades, and from there into small-scale property management, each step not dramatic on its own, but part of a larger pattern that only made sense when viewed across decades. What separated him from others wasn't luck alone, though. Timing played its part, but a kind of attention that I have never been able to fully replicate in my own life. He noticed things. He noticed neighborhoods before they changed. He noticed which buildings were being neglected and which ones still had structural integrity beneath their decay. He noticed patterns in people, in markets, in the slow shifts that most others ignored because they required patience to interpret. And above all, he understood the value of waiting, not passive waiting, but what he once described to me as strategic patience, the discipline of not acting until the conditions justified it, even when acting sooner might have felt more satisfying. By the time he was 60, Ezra Whitmore owned 14 properties across the greater Detroit area. 8 residential rentals that generated steady income, 3 mixed-use commercial buildings that required a different kind of oversight, a warehouse leased to a packaging company, and the house on Calvert Street in northwest Detroit, where he had lived since 1971. That house was not the most valuable asset he owned, at least not for most of his life. But it was the one that anchored everything else. It was where decisions were made, where documents were signed, where mornings began with a newspaper spread across the kitchen table and a quiet that felt less like absence and more like intention. Even into his 80s, long after most men would have outsourced the physical demands of maintaining a property, he insisted on mowing his own lawn every Saturday morning. When I asked him why once, he looked at me as if the question itself required correction and said, "The lawn doesn't care how old I am." It was his way of saying that certain standards were not negotiable, that responsibility did not diminish just because time passed. He was not warm in the way people often expect from a grandfather. He did not offer easy affection, did not say "I love you" casually, did not attend every school event or call simply to check in, but what he offered instead was something that over time proved more enduring. When he spoke to you, he listened for the real answer. When he asked a question, it was because he expected you to think about it. He treated even children as if their thoughts mattered, not in a performative way, but in a way that carried weight. I remember sitting at his kitchen table when I was 9 years old, struggling with long division, frustrated in the way only a child can be when something refuses to make sense. He watched me for a while without interrupting, then asked, "What do you do when you can't see the path forward?" I told him I didn't know. He nodded as if that were an acceptable starting point and said, "You stop moving and you look at what you have. Not what you wish you had, what you actually have." At the time it felt like an answer that didn't quite fit the problem in front of me. But years later, when I found myself facing decisions that carried real consequences, I understood that he had never been talking about math. That was how he taught indirectly, without framing it as instruction, without repeating himself to ensure the lesson had landed. He assumed that if something was worth understanding, you would return to it on your own when you were ready. And I did. At 22, during one of the most difficult years of my life, I wrote that sentence down in a notebook, and I have revisited it in one form or another almost every day since. His influence on me was not built through constant presence or overt guidance, but through moments that embedded themselves quietly and revealed their meaning over time. He showed me, without ever stating it explicitly, that clarity mattered more than comfort, that decisions should be made based on reality rather than desire, and that responsibility was not something you claimed but something you demonstrated, consistently. To people who did not know him well, he could seem distant, even indifferent. But that interpretation missed the essential truth of who he was. He paid attention to people, to details, to patterns, and that attention translated into a form of care that was less visible but no less real. When he looked at you, you felt accounted for, as if your existence had been noted and considered within a larger framework that he carried quietly in his mind. He did not need to say much because what he observed informed everything he did, and when he made decisions, whether in business or in family matters, they were rarely impulsive. They were the result of years of observation, of accumulated understanding, of a perspective that extended beyond the immediate moment. His philosophy was not something he ever formalized, but it was evident in the way he lived. He believed in building slowly and avoiding unnecessary risk and positioning yourself so that when opportunity appeared, you were ready to act. He believed that most people moved too quickly, that they reacted, instead of assessing, that they allowed emotion to override judgment. And he believed, perhaps most importantly, that what you chose to do consistently mattered more than what you said you intended to do. That belief shaped his relationships as much as his business decisions. He did not reward proximity alone or effort alone or even loyalty in its simplest form. He responded to something more complex, an alignment between what a person said, what they did, and what they understood about the world around them. Looking back now, I can see how deeply those values influenced the way I built my own life. My decision to become an estate attorney was not something he directed, but it followed the same logic he had lived by. It required attention to detail, the ability to interpret intention, and while we never had a conversation where he explicitly connected his life to mine in that way, I understood over time that he had been watching just as he watched everything else. He had been observing how I approached problems, how I responded when things did not go as planned, how I handled the difference between what I wanted and what was actually in front of me. That is what made his eventual decisions carry the weight that they did. They were not sudden, not arbitrary, not the result of a single moment or influence. They were the outcome of a lifetime of observation of a man who had spent decades refining his understanding of people and patterns and consequences. And whether others recognized it or not, whether they agreed with it or not, those decisions were entirely his own. When my grandfather's will was read, there was no confusion about its structure, no ambiguity in the language, no gaps that required interpretation beyond what had already been carefully documented. Ezra Whitmore had arranged his estate with the same deliberate precision that had defined every major decision in his life, and the distribution reflected not only the value of his assets but the logic behind how he believed they should continue to function after he was gone. The total estate was substantial, built over decades of disciplined investment and strategic patience, but it was not divided in a way that aligned with simple expectations of fairness or proximity. Instead, it followed a pattern that only made full sense if you understood how he evaluated responsibility, capability, and intention. He left the house on Calvert Street, his home for over 50 years, and the warehouse on Livernois Avenue to me. Together. Those two properties were appraised at approximately $5.2 million at the time of his death. The house having significantly increased in value due to the revitalization of the surrounding neighborhood, and the warehouse having become a stable income-generating asset after years of expansion and careful leasing decisions. These were not just financially valuable properties, they were in many ways the core of what he had built in the later stages of his life. The rest of the estate was distributed with equal clarity. My uncle Roderick, his surviving son, received the 8 residential rental properties assets that required consistent management and provided reliable if less dramatic returns. Their combined value was substantial, though lower than the portion I inherited, and they represented the steady foundation of the portfolio rather than its peak. The 3 mixed-use commercial buildings were divided into equal shares among my cousins, Damon and Brianna, and a non-profit vocational training organization that my grandfather had supported for over a decade. That inclusion surprised some people, but it did not surprise me. He had always believed in practical skill development, in the kind of work that builds independence over time, and the organization reflected that belief. What he left was not just money but a continuation of his values embedded directly into the structure of the estate itself. On paper, the distribution could be reduced to numbers and percentages to a comparison of who received more and who received less, but that kind of analysis missed the underlying intent. My grandfather did not divide his assets based on sentiment alone, nor did he follow a formula that prioritized bloodline or proximity in a predictable way. He assigned responsibility. The residential properties required ongoing attention, tenant management, maintenance decisions, the kind of work my uncle had already been involved in for years. The commercial buildings shared between my cousins and the nonprofit created a structure where financial benefit and broader purpose coexisted. And the house and the warehouse, the most symbolically and financially significant pieces, were given to me, not because I had asked for them, and not because I had positioned myself to receive them, but because, in his assessment, I would understand what they required. At the time the will was read, I did not immediately interpret his decision in those terms. I understood the legal clarity of it, of course. I recognized that the documents were properly executed, that the structure was sound, that the distribution would withstand scrutiny. But the meaning behind it, the reason those particular assets had been placed in my hands, took longer to fully absorb. The house on Calvert Street was more than property. It was where his routines had taken shape, where his habits had solidified into something resembling identity. It was a place defined not by sentimentality but by continuity, by the quiet persistence of maintenance, of showing up, of keeping something in order over a long period of time. The warehouse, on the other hand, represented growth adaptation, the ability to recognize when something could be expanded, improved, made more efficient. Together they formed a kind of balance between stability and evolution, between holding on and moving forward. What he left me then was not simply the most valuable portion of the estate. He left me the responsibility of understanding both sides of that balance and maintaining it without distorting it. That was not a gift in the conventional sense. It was an expectation, one that had been formed over years of observation rather than any single conversation. And while others might have seen the distribution as uneven, as something that required explanation or correction, I came to understand that it was in fact entirely consistent with who he had always been. He had never made decisions based on what would appear fair from the outside. He made decisions based on what he believed would work, what would hold its shape over time, what would not collapse under pressure, what would continue to function in his absence. That distinction became critical once the will moved from being a private document to a public point of conflict, because when people looked at the numbers alone, when they compared values without context, it created a version of the story that seemed incomplete, even suspicious. Why this distribution? Why these assets? Why me? Those questions, once asked, demanded answers, and in the absence of a shared understanding of his reasoning, they created space for doubt. But from where I stood, the logic was clear, even if it was not immediately comfortable. My grandfather had spent his life building something carefully, and in the end, he had distributed it in a way that reflected that same care. Whether others accepted that or not did not change the fact that the decision was his, fully formed and deliberately executed long before anyone thought to challenge it. The conflict did not begin with the lawsuit, at least not in any way that could be formally documented. It began earlier, in the quiet space between expectation and reality, in the unspoken assumptions that had been allowed to exist for so long that they hardened into something resembling certainty. My uncle, Roderick Whitmore, had spent years as the one who stayed. He was the son who remained in Detroit when others left. The one who managed my grandfather's properties when age made it more difficult. The one who drove him to medical appointments, who sat beside him during hospital visits, who handled the practical, unglamorous responsibilities that accumulate in the later years of a man's life. None of that was performative. None of it was done with visible resentment. He did those things because in his understanding of family, that was what you did. And for years that understanding went unchallenged. No one explicitly told him that proximity to care would translate into proximity to inheritance, but no one told him it wouldn't either. The assumption settled in, gradually reinforced by routine, by habit, by the quiet logic that, if you are the one who carries the weight, you will also be the one who receives the recognition when everything is accounted for. That was the expectation. The reality, when it arrived, did not align with it. When the will was read and the distribution made clear, there was a moment, subtle, almost imperceptible, where something shifted in him. It was not an outburst, not an immediate objection, not the kind of reaction that draws attention in a room already heavy with grief. It was quieter than that. It was the look of a man recalculating, of someone mentally rearranging a structure he had assumed was stable, only to realize that its foundation had been built on something he had never actually confirmed. He received 8 residential properties, a substantial inheritance by any objective measure, assets that reflected both value and trust in his ability to manage them. But it was not what he had expected. An expectation once formed over years does not dissolve easily in the face of contradiction. It resists. It searches for explanation. It demands that the gap between what should have been and what is be accounted for in a way that preserves the original belief. He did not say anything that day. Not at the reading, not afterward, not in the immediate weeks that followed. But silence is not absence. It is often the space where conclusions are being formed, where narratives begin to take shape without needing to be spoken aloud. When he called me 3 weeks later, his tone was measured, controlled, the kind of neutrality that signals something more complicated beneath it. He asked if I had discussed the will with my grandfather before it was finalized. The question itself was simple. The weight behind it was not. I told him the truth that I had not been involved in the drafting, that my grandfather had only mentioned in passing that he intended for me to have the house on Calvert Street. That was the extent of it. No discussions of value, no influence over distribution, no role in the process beyond being named in the outcome. He listened. He acknowledged what I said, and then the conversation ended without resolution. Without any explicit challenge, but also without the kind of acceptance that would have closed the matter. What I understand now in a way I did not fully grasp then is that by the time he made that call, he had already begun to construct an explanation. Not consciously, perhaps not with the intention of fabricating something untrue, but with the need to reconcile a reality that did not fit within the framework he had relied on for years. Because if the will reflected exactly what my grandfather intended, then it meant that all the assumptions built around proximity care and expectation were incomplete. It meant that the equation he had been working from was missing variables he had never considered. And that is a difficult conclusion to accept, especially when it reframes not just an outcome, but an entire understanding of what your role in someone's life has meant. The alternative explanation, subtle at first, then more defined, was that something had interfered with that intention, that the will as it stood was not a pure expression of my grandfather's decisions but a document shaped by influence, by access, by manipulation. It did not require a dramatic leap to get there. I was an estate attorney. I understood the system. I knew the process. From a distance. Those facts could be rearranged into something that looked less like coincidence and more like opportunity. And once that possibility entered the narrative, it provided a structure that made everything else easier to accept. If the will was influenced, then the distribution made sense. If the will was altered, then the outcome could be challenged. If there was wrongdoing, then there was something to correct. By the time the lawsuit was filed, those possibilities had solidified into formal allegations. The complaint stated that I had exercised undue influence over an elderly man in declining health, that I had gained inappropriate access to his estate planning process, and that the will itself was not authentic, that it had been altered, fabricated or executed under conditions that rendered it legally invalid. The most severe claim, the one that shifted everything into a different category entirely, was the accusation of forgery. It was not framed as speculation. It was presented as a plausible explanation, supported, they claimed, by discrepancies in the signature and inconsistencies in the document. In legal terms, it was a direct challenge to the validity of the will. In personal terms, it was an accusation that I had violated not just the law but the trust of the man whose decisions I was now defending. I remember the moment I first read the complaint, sitting alone in my car in the parking structure beneath my office. There is a difference between understanding something intellectually and experiencing it directly, and in that moment the distinction was absolute. I had spent years advising clients on how to respond to disputes like this, how to separate emotion from strategy, how to focus on evidence rather than accusation. But reading my own name in that context, attached to claims that contradicted everything I knew to be true, created a kind of stillness that was difficult to move through. Not panic, not even anger at first, but a pause, a recognition that something fundamental had shifted, that the situation had moved beyond misunderstanding into something that would require formal resolution. For Roderick, the decision to file the lawsuit was, I believe, less about malice than about necessity, at least as he understood it. He needed the narrative to hold. He needed the explanation to justify the discrepancy between expectation and reality. And once that narrative was established, once it was reinforced by legal counsel willing to pursue it, the path forward became almost inevitable. Lawsuits have their own momentum. They take on a structure that moves independently of the emotions that initiated them. What begins as a question becomes a claim. What begins as doubt becomes an argument. And what begins as a private conflict becomes a matter of public record. By the time it reached that stage, the conflict was no longer contained within the family. It had been formalized, documented, and set in motion in a way that could not be easily reversed. The hardest part, perhaps, was not the accusation itself, but the realization that from his perspective it made sense, not because it was true, but because it aligned with the version of events he needed to believe. That understanding did not lessen the impact. It did not make the process easier, but it did clarify something essential about the nature of the conflict. This was not simply a legal dispute over assets. It was the collision between two interpretations of the same set of facts, one grounded in evidence, the other in expectation, and the determination on his part to resolve that collision in a way that restored the balance he believed had been disrupted. The emotional cost of the lawsuit was not immediate in the way legal consequences are immediate. It unfolded slowly, settling into the spaces of my life that had once felt stable and predictable, altering them in ways that were difficult to name but impossible to ignore. What had once been a family imperfect but intact in its own quiet way became something fractured, defined less by shared history and more by the silence that replaced it. Damon was at the center of that silence. We had grown up together, close in the way cousins sometimes are when proximity and timing align just right, sharing holidays, conversations, the kind of familiarity that doesn't require constant maintenance to remain intact. Even as adults, when life had pulled us in different directions, there had always been an understanding that the connection was still there, available if needed. When the lawsuit was filed, I expected, perhaps naively, that he would reach out, if not to defend me, then at least to acknowledge what was happening. I expected some recognition of the years that had come before, some indication that the situation was more complicated than the claims being made in his father's name. What I received instead was nothing. No call, no message, no attempt to explain his position or distance himself from it. The absence of communication became its own form of communication, one that was clearer than any statement could have been. It told me that whatever loyalty he felt toward his father outweighed whatever connection he felt toward me, and while I could understand that in theory, experiencing it directly was something else entirely. Brianna, his sister, approached it differently, though, not in a way that resolved the tension so much as it softened one edge of it. She called me several weeks after the lawsuit had been filed, her voice unsteady in a way that made it clear she had been thinking about the call for some time before making it. She told me she wasn't part of what was happening, that she didn't agree with the accusations, that she believed our grandfather had known exactly what he was doing. But she also told me she couldn't step into the conflict publicly, couldn't oppose her father in a way that would fracture her own position within the family. It was not a defense, not in any formal sense, but it was an acknowledgement, and in a situation where so much had become uncertain, that acknowledgement mattered more than I expected it to. We both cried quietly. The kind of restrained emotion that comes when there is too much to say and no clear way to say it without making everything worse. After that call, we returned to a kind of distance, not hostile but cautious, as if maintaining even that small connection required careful handling. Outside of those relationships, the lawsuit began to seep into other areas of my life, altering the way I moved through my days. At work, I maintained the same level of professionalism, the same attention to detail, the same expectations I had always held for myself. But there was an added layer beneath it, a constant awareness that my own integrity, something I had built over years of practice, was now being questioned in a public forum. My colleagues were supportive in the ways that mattered. They did not treat me differently, did not reduce my responsibilities or speak about the situation in hushed tones that would have made it feel more isolating. But even with that support, there was a shift, subtle but persistent, in how I experienced my own work. Every case I handled, every document I reviewed carried an additional weight, a reminder of what was being said about me outside those walls. I continued because stopping was not an option. But continuing required a level of focus that left little room for anything else. At home, the impact was more personal, more difficult to compartmentalize. My daughter Imani was 11 at the time, old enough to sense that something was wrong but not old enough to fully understand the complexities of it. Children do not need full explanations to recognize tension. They read it in the pauses, in the way conversations stop when they enter a room, in the slight delay before a response is given. She asked me once directly whether what was happening with her uncle was serious. I told her that it was, but that I was handling it. She thought about that for a moment, then asked the question that mattered more than any legal argument, whether I had done what I was being accused of. When I told her no, she accepted it immediately, without hesitation, without doubt, and returned to whatever she had been doing before. That trust, simple, unquestioned, was both a source of strength and a reminder of what was at stake. It grounded me in a way that nothing else could, but it also made the accusations feel heavier, because they existed in direct contrast to the version of me that mattered most in that space. The sense of betrayal, when it finally settled in fully, was not sharp or explosive. It was gradual, layered, difficult to isolate into a single moment. It came in pieces, in the silence from Damon, in the formal language of the complaint, in the realization that my uncle had moved from private doubt to public accusation without ever attempting a genuine conversation about what had happened. It was not just that he believed something untrue. It was that he had chosen to act on that belief in a way that required me to defend myself against him, to step into a position where the family connection was replaced by opposing roles in a legal process. That shift from family to adversary was the most difficult to reconcile. It changed the context of every shared memory, every past interaction, forcing me to reconsider what had been real and what had been assumed. At the same time, there was a part of me that understood even as I struggled with the consequences. I understood how expectation can harden into something that feels like entitlement, how the gap between what you believe should happen and what actually happens can create a need for explanation that overrides other considerations. That understanding did not excuse what had been done, but it complicated the emotional response. It made it harder to hold on to anger in a clean, uncomplicated way. Because the situation was not built on a single act of malice, but on a series of assumptions that had gone unchallenged for too long. What replaced that anger was something quieter, more enduring, a sense of loss, not just of the relationships as they had been, but of the possibility that they might have become something different under other circumstances. Over time, the lawsuit became not just a legal battle but an emotional landscape I had to navigate daily. It shaped how I interacted with people, how I measured my own reactions, how I balanced the need to remain composed with the reality of what I was experiencing internally. There were moments of clarity, moments where the path forward felt defined and manageable, and there were moments where the weight of it all felt disproportionate, where the cost extended beyond what any legal outcome could address. Through it all, I continued to move, not because I was unaffected, but because stopping would have meant allowing the situation to define me in a way I was not willing to accept. In the end, what the lawsuit revealed was not just the fragility of legal claims or the strength of evidence, but the complexity of relationships under pressure. It showed how quickly connection can give way to distance, how silence can carry as much meaning as words, and how trust once disrupted does not easily return to its original form. The legal outcome would eventually provide resolution in a formal sense, but the emotional impact remained reshaping the way I understood my family. My role within it, and the boundaries between what can be repaired and what must simply be accepted as changed. The legal battle did not begin in the courtroom. It began in preparation, in the quiet, methodical work that takes place long before any argument is presented publicly. From the moment the complaint was filed, the case moved into a structured process that I knew well from the perspective of an attorney, but experiencing it as the defendant required a different kind of discipline. My attorney, Simone Achebe, approached the case with a clarity that immediately shaped our strategy. She did not treat the allegations as abstract or exaggerated, even when parts of them were clearly unsupported. Instead, she identified the central threat early: the forgery claim. Undue influence, while serious, is a familiar argument in contested wills, one that relies on patterns of behavior, access, and persuasion. Forgery, however, operates differently. It is technical, evidentiary, and if substantiated, devastating. It does not suggest influence, it asserts fabrication. That distinction meant our preparation could not rely on general credibility alone. It required precision documentation and expert analysis that could withstand scrutiny at the highest level. The first phase of preparation involved gathering every relevant document connected to my grandfather's estate planning history. This was not limited to the contested will itself, but extended across years of records, prior versions of the will, property transfers, personal correspondence, tax filings, and anything that contained his signature. The goal was not simply to demonstrate consistency, but to create a comprehensive record that could be analyzed in context. At the same time, Simone anticipated that the opposing side would rely on a document examiner, and she made the decision early to retain our own expert rather than respond reactively later. That decision shaped the entire trajectory of the case. Dr. Richard Holt was not chosen casually. His background alone established a level of authority that would be difficult to challenge over 2 decades. In the FBI Laboratory Division's Questioned Documents Unit, hundreds of cases, a reputation for testimony that was both precise and resistant to cross-examination. But beyond credentials, what mattered was his methodology. He approached the documents without assumption, examining not just the signature in question but the full body of available material. For months, his analysis unfolded in a way that was almost invisible to anyone outside the process. There were no dramatic breakthroughs, no sudden revelations, just the steady accumulation of data comparisons and conclusions built on careful observation. He requested additional records, including my grandfather's medical history, something that would later prove critical. While our preparation moved forward with that level of detail, the opposing side constructed their case around a different approach. Their expert, Theodore Bosch, produced a report that focused on inconsistencies in pen pressure, letter formation, and structural elements of the signature. The language was cautious phrases like inconsistent with known samples rather than definitive claims, but the interpretation of that language by their legal team was far less restrained. Carlton Webb, my uncle's attorney, made it clear from early filings that he intended to frame the case in a way that emphasized suspicion over nuance. In his narrative, technical inconsistency became evidence of deliberate alteration, and the distinction between possibility and proof was blurred in favor of impact. Simone anticipated that approach and structured our response accordingly. Our strategy was not to match their tone but to dismantle it systematically. Every claim where they focused on isolated characteristics of the signature, we would present a full pattern. Where they suggested irregularity, we would demonstrate consistency within a larger context. And where they relied on interpretation, we would rely on documented correlation. This required not just confidence in our position but patience. Legal strategy at this level is not about reacting quickly. It is about building a foundation that cannot be easily undermined once presented. As the case moved closer to trial, the atmosphere shifted. What had been largely procedural became more immediate, more tangible. Depositions were conducted, each one a controlled environment, where testimony was given under oath, where language mattered in ways that extended beyond ordinary conversation. I gave my deposition with the awareness that every answer would be examined, not just for content, but for consistency with everything else in the record. The opposing counsel attempted to establish a narrative of access and influence, asking detailed questions about my interactions with my grandfather, my knowledge of his assets, my familiarity with estate planning processes. None of the questions were unexpected, but answering them required a careful balance, being direct without over-explaining, precise without appearing defensive. Simone intervened when necessary, objecting to questions that crossed into speculation or mischaracterization, maintaining the structure of the exchange. Outside of those formal settings, the tension was constant, though often unspoken. Preparation sessions extended late into the evening, reviewing documents, refining arguments, anticipating lines of attack. There is a particular kind of focus that emerges in those moments where external distractions fall away and everything narrows to the task at hand. But beneath that focus, there was an awareness that the outcome of this process would extend beyond the legal ruling. It would define, in a public and permanent way, whether the accusations against me held any weight. The submission of expert reports marked a turning point. Bosch's report was filed, first establishing the framework for their argument. When Dr. Holt's report was submitted 3 weeks before trial, it shifted that framework entirely. At 47 pages, it did not rely on general statements. It detailed every aspect of his analysis, the comparison of signature samples across a 12-year period, the identification of patterns consistent with my grandfather's handwriting, most importantly, the integration of medical records documenting the progression of his essential tremor. That element had been absent from Bosch's analysis, and its absence was not a minor oversight. It was a critical gap that undermined the foundation of his conclusions. Holt's report demonstrated that the variations identified as suspicious were not anomalies, but predictable results of a documented medical condition. The tremor affected pen pressure line, stability, and letter formation in ways that could be traced consistently across authenticated documents from the same period. What Bosch had interpreted as inconsistency, Holt reframed as continuity within altered physical conditions. The difference between those interpretations was not simply academic. It redefined the entire argument. If the variations were expected, then they could not serve as evidence of forgery. As the trial approached, the atmosphere in the courtroom reflected the weight of what had been built on both sides. There was no overt hostility, no dramatic confrontation, but a controlled tension that permeated the proceedings. Each side understood the stakes, and each presentation was delivered with that awareness. Opening statements set the tone, Webb emphasizing doubt, suggesting that the integrity of the document was in question, while Simone focused on clarity, outlining the evidence that would demonstrate its validity. When testimony began, the structure of the case unfolded as expected. Sandra Yee provided detailed accounts of the drafting process, reinforcing the legitimacy of the will's execution, but it was clear that the central confrontation would occur during the expert testimony. Bosch's conclusions were presented first framed in a way that emphasized uncertainty. He did not claim definitive forgery, but he established enough ambiguity to support the narrative that something was wrong. Then Dr. Holt took the stand and the dynamic shifted. His testimony was measured, deliberate, and grounded entirely in documented analysis. He explained his methodology step by step, ensuring that each conclusion was supported by data that could be traced and verified. There was no exaggeration, no attempt to overstate his findings. That restraint paradoxically made his testimony more compelling. When he addressed the discrepancies identified by Bosch, he did so not by dismissing them, but by placing them within the broader context of the medical evidence. Each point was clarified, each gap addressed, until the initial claims of inconsistency lost their force. Cross-examination tested that clarity, but it did not break it. Webb attempted to challenge the objectivity of Holt's methodology to suggest that interpretation played a larger role than the expert acknowledged. Holt responded with detailed explanations that reinforced the structure of his analysis. He was asked about the completeness of the medical records. He enumerated them precisely. He was asked about the possibility of differing expert opinions. He distinguished between interpretive disagreement and incomplete data. The exchange was controlled, but the outcome was evident in the lack of follow-up questions, in the gradual narrowing of the opposing argument. By the time testimony concluded, the tension that had built throughout the preparation phase found its resolution not in a dramatic moment but in the accumulation of evidence that had been carefully constructed over months. The legal battle from its earliest stages had been defined by that contrast between assertion and verification, between narrative and documentation. And in that contrast, the outcome had already begun to take shape, even before the judge delivered her ruling. The turning point of the entire case, quiet in delivery but decisive in impact, rested on the evidence presented by Dr. Richard Holt, whose analysis did not simply counter the opposing argument, but fundamentally reframed it. Up until that moment, the forgery claim had operated in a space of manufactured ambiguity, sustained by selective observation and the strategic use of uncertainty. Theodore Bosch, the opposing expert, had built his conclusions on visible irregularities in my grandfather's signature variations, in pen pressure, inconsistencies in letter formation, subtle distortions in line quality. On the surface, these observations carried weight. To an untrained eye, they suggested instability, deviation from a known standard, and therefore the possibility that the signature was not authentic. But what Bosch's analysis lacked, and what ultimately unraveled it, was context. He had isolated the signature as an object to be compared rather than as the product of a human hand operating under specific physical conditions over time. Dr. Holt approached the question differently from the outset. He did not begin with the assumption that the signature was either genuine or forged. Instead, he constructed a framework of comparison that extended across years of documented handwriting, assembling a comprehensive archive of my grandfather's signatures from multiple sources: legal documents, personal correspondence, financial records, and most critically, prior versions of his will. This longitudinal approach allowed him to observe not just what the handwriting looked like at a single point, but how it had evolved, how it had responded to age, to health, to the natural degradation of fine motor control. And within that broader pattern, the so-called inconsistencies began to take on a different meaning. The key to Holt's analysis, and the element that Bosch had either overlooked or failed to incorporate, was the medical documentation of my grandfather's essential tremor. This was not speculative. It was recorded in detail across multiple medical reports from his final years, describing a progressive condition that affected his hand stability, his grip, his ability to maintain consistent pressure while writing. Holt did not treat this as peripheral information. He treated it as central. He mapped the characteristics of the tremor directly onto the variations observed in the handwriting, demonstrating that the irregularities Bosch had flagged were not anomalies, but expected outcomes of a documented neurological explains of condition. The slight wavering in line quality, the uneven pressure distribution, the subtle distortion in certain letter forms, these were not signs of forgery. They were signatures quite literally of a hand adapting to physical limitation. What made Holt's testimony particularly effective was not just the content of his conclusions, but the clarity with which he explained the relationship between the medical condition and the handwriting. He did not rely on abstract language or technical obscurity. Instead, he walked through the evidence step by step, showing how each variation aligned with the known effects of tremor on motor function. He referenced specific documents, specific timeframes, demonstrating consistency across samples that had been independently verified as authentic. The contested signature, when placed within that continuum, did not stand out as an outlier. It fit precisely where it should, reflecting the same patterns, the same limitations, the same physical reality as every other signature produced during that period of my grandfather's life. The contrast between the two experts became increasingly stark as this analysis unfolded. Bosch's report, while careful in its wording, now appeared incomplete, its conclusions built on a narrow dataset that failed to account for critical variables. Holt did not attack Bosch personally, nor did he dismiss his observations outright. Instead, he reframed them, acknowledging that the variations existed but demonstrating that their interpretation had been fundamentally flawed. This distinction mattered. It shifted the discussion from one of competing opinions to one of methodological accuracy. It was no longer a question of which expert was more persuasive, but which analysis had incorporated all relevant data. The breaking point came during cross-examination when the opposing counsel attempted to reduce the difference between the two experts to a matter of subjective disagreement. It was a strategic move designed to preserve the credibility of their position by suggesting that reasonable professionals could arrive at different conclusions from the same evidence. Holt's response was measured, but it carried a precision that left little room for reinterpretation. He stated clearly that Bosch's conclusions did not account for the medical records, and that if they had, the interpretation of the handwriting would necessarily have changed. This was not, he emphasized, a divergence of opinion within a shared framework. It was the result of an incomplete analysis. That statement did more than clarify the technical issue. It exposed the structural weakness of the forgery claim, because if the foundational evidence supporting that claim was based on an analysis that omitted critical information, then the claim itself could not stand. The ambiguity that had sustained it collapsed under the weight of a more comprehensive explanation. What had been presented as suspicious became explainable. What had been framed as irregular became consistent. And in that shift, the narrative that had been constructed around doubt lost its coherence. For me, sitting in that courtroom, the significance of that moment was not dramatic in the way people often imagine turning points to be. There was no visible reaction, no sudden change in tone, but there was a clarity that settled in a recognition that the case had moved beyond speculation into something firmly grounded in evidence. The accusations that had felt for months like an abstract threat, something that existed in documents and arguments, were now being dismantled in real time. Not through force, but through explanation. What Holt provided was not just a defense of the signature's authenticity. He provided a restoration of context, a return to the reality of my grandfather as a person whose body had changed over time, whose handwriting reflected those changes, and whose final act of signing his will was consistent with everything that had come before. In doing so, he removed the space in which doubt had been allowed to grow. And without that space, the forgery claim had nowhere left to stand. The courtroom on the final day of testimony carried a different kind of stillness than it had before, not the tension of uncertainty, but the quiet anticipation that comes when everything that could be said has already been placed on record. The arguments had been made, the evidence presented, the experts examined and cross-examined, and what remained was the judge's assessment, a process that would condense months of preparation and weeks of proceedings into a single, decisive conclusion. Judge Diane Forsyth did not prolong the moment. After a brief recess, she returned to the bench and began delivering her ruling directly. Her tone measured, her language precise, the cadence of someone accustomed to separating fact from assertion without hesitation. She stated clearly that the will of Ezra James Whitmore, as filed with the Wayne County Probate Court, was authentic, properly executed, and legally valid. There was no ambiguity in her phrasing. No qualification that left room for reinterpretation. Each element of the claim brought against me was addressed in turn, and each was dismissed with equal clarity. The allegation of undue influence, she noted, had not been supported by evidence demonstrating coercion, manipulation, or compromised intent. The testimony and documentation instead reflected a consistent pattern of independent decision-making by my grandfather, reinforced by the detailed accounts provided by the drafting attorney Sandra Yee. When she turned to the forgery claim, the tone shifted slightly, not in volume but in emphasis. she stated that the accusation was not only unsupported, but directly contradicted by the forensic analysis presented by the defense. Dr. Holt's testimony, she explained, had established a comprehensive and credible basis for concluding that the signature was genuine, supported by both longitudinal handwriting comparison and medical documentation. In contrast, the opposing expert's analysis had failed to account for critical evidence, rendering its conclusions insufficient to sustain the claim. Then came the part that extended beyond the immediate question of the will's validity. The judge addressed the nature of the allegations themselves, noting that a claim of forgery, particularly one made against a practicing estate attorney with no history of misconduct, carried significant professional implications and required a corresponding level of evidentiary support. That standard, she stated, had not been met. As a result, she imposed sanctions, ordering my uncle and his legal team to pay a portion of the defense costs, a figure that reflected not only the expense of the proceedings, but the seriousness of advancing claims without adequate foundation. It was a formal acknowledgement that the case had crossed a threshold, moving from dispute into something that had caused measurable harm. The reactions in the room were subdued but distinct in their own ways. My uncle did not look at me. He remained still as the ruling was delivered, his expression controlled, his posture unchanged, as if any visible response would concede more than he was willing to give. When it was over, he stood, when his attorney stood, gathered his things, and walked out with deliberate composure, maintaining the same distance he had held throughout the trial. Damon, seated behind him, followed a moment later. Before he turned away, he looked at me briefly but directly for the first time since the proceedings had begun. It was not a gesture that could be easily interpreted. There was no apology, no acknowledgement, only a look that suggested recognition without resolution, as if the outcome had clarified something without repairing what had been broken. For me, the ruling did not arrive as a surge of relief or triumph. It settled in more quietly, as confirmation of what I had known from the beginning, but had been required to prove in a public and structured way. The legal validation mattered, of course. It restored the integrity of the will, affirmed the legitimacy of my grandfather's decisions, and cleared my name in a professional context. But it did not undo the process that had led there. It did not erase the months of accusation, the strain on relationships, the shift in how I was perceived by those who had chosen to believe a different version of events. What it did provide was clarity, final and unambiguous, and in that clarity there was a kind of resolution, not emotional, not relational, but factual. The court had spoken, and in doing so it had drawn a line between what had been alleged and what had been proven, leaving everything else to exist in the space beyond its jurisdiction. The legal victory brought closure in the way the law defines it, clear, documented, and final. But outside the courtroom, the aftermath unfolded in a quieter, more complicated way, one that had no formal resolution and no structured process to guide it. What had once been a family, however, imperfect, no longer existed in the same form. The lawsuit had drawn lines that could not be easily erased, transforming relationships into distances that felt both intentional and irreversible. There were no dramatic confrontations after the ruling, no attempts to repair what had been broken in the months leading up to it. Instead, there was silence, a sustained, deliberate absence of communication that settled into place as if it had always been there, revealing itself not as a temporary reaction but as a new reality. My uncle did not contact me after the trial. There was no acknowledgement of the outcome, no attempt to revisit the accusations that had been publicly dismissed, no indication that the ruling had altered his understanding of what had happened. Whatever explanation he had constructed before the lawsuit remained intact even in the face of evidence that contradicted it. That perhaps was the most difficult part to accept, not that he had been wrong, but that he seemed unwilling or unable to reconsider. Damon followed that same pattern of distance. The brief look he gave me in the courtroom became the last direct interaction we had. There were no messages afterward, no effort to bridge the gap that had formed between us. The absence of hostility did not make the distance easier. If anything, it made it more complete. There was nothing to respond to, nothing to resolve, only the recognition that something fundamental had ended without being formally declared. Brianna remained the one exception, though even that connection existed within limits. Her message after the ruling, simple, restrained, acknowledged the outcome without reopening the conflict. It was a gesture of support but also a boundary, a way of maintaining a connection without stepping back into the complexity that had defined the previous months. We did not return to regular communication, did not attempt to rebuild what had been altered. What remained between us was smaller, more careful, defined by what could be sustained without creating new strain. In some ways that made it more meaningful, but it also underscored how much had changed. The sense of loss that followed was not immediate in a dramatic sense. It did not arrive all at once, but instead appeared in moments, small, ordinary situations, where the absence of what had once been became noticeable. Holidays felt different, quieter in a way that could not be attributed to any single factor. Conversations that would have included certain voices now moved forward without them. There was no single point where I could say the family had broken. It was something that revealed itself gradually through accumulation rather than event. And unlike the legal case, there was no clear outcome to point to, no resolution that could be documented and referenced. There was only the ongoing experience of distance, of knowing that certain relationships had shifted into a form that would not return to what they had been. At the same time, the emotional impact was not defined solely by what was lost. There was also a process of adjustment, of redefining what remained and how to move within it. The clarity of the court's ruling provided a foundation. In one sense, it established the facts, confirmed the validity of my grandfather's decisions, and removed the uncertainty that had surrounded the accusations. But emotional clarity operates differently from legal clarity. It requires acceptance of things that cannot be corrected, acknowledgement of limits that cannot be overcome through argument or evidence. Over time, I began to understand that the distance created by the lawsuit was not something to be resolved, but something to be recognized and incorporated into the reality of my life as it now existed. The silence in that sense became less of an absence and more of a condition. It did not demand constant attention, but it remained present, shaping the contours of what was possible and what was not. There were no ongoing conflicts, no continued disputes, just a settled separation that replaced what had once been an open, if imperfect, connection. And while that separation carried its own weight, it also created a kind of clarity, an understanding of where boundaries now existed, of what could be relied upon and what could not. In the end, what I carried forward from the aftermath was not a sense of victory but a recognition of cost. The legal outcome had affirmed the truth, had protected what needed to be protected, but it had not preserved the relationships that existed before the conflict began. Those had been altered in ways that extended beyond the reach of any ruling. What remained was a quieter, more defined version of my life. One that included both the stability of what had been secured and the absence of what had been lost. In the months that followed the trial, life did not return to what it had been before, but it did settle into something steadier, shaped less by conflict and more by intention. The legal resolution had clarified ownership, but what mattered more over time was what I chose to do with what had been entrusted to me. The house on Calvert Street, in particular, carried a weight that extended beyond its financial value. It was not simply a property to be occupied or sold. It was a place that had been maintained with quiet consistency for over 50 years, a physical reflection of my grandfather's approach to responsibility. I chose not to move into it. My life, and more importantly my daughter's life, was rooted elsewhere, in a community and routine that provided stability. Instead, I approached the house the way I believed he would have, by preserving its function and integrity without imposing unnecessary change. I invested in repairs where they were needed, refinished what time had worn down, and left intact what did not require alteration. The kitchen table remained where it had always been, a small, deliberate decision that carried more meaning than any larger renovation could have. The warehouse on Livernois Avenue required a different kind of attention, one that aligned more closely with the practical side of my grandfather's legacy. It was already leased to a manufacturing company, its operations steady, its income predictable. Managing it meant maintaining that stability, ensuring that the agreements in place continued to function as intended, and making decisions that prioritized long-term reliability over short-term gain. The income it generated became part of a broader structure in my own life. A portion was directed toward a college fund for my daughter, a decision grounded in the same principle my grandfather had followed, building something that would extend beyond the present moment. Another portion, though not required by the terms of the will, was allocated to the vocational training nonprofit he had supported for years. That choice was not an obligation but an acknowledgement. It reflected an understanding of what he had valued, of the belief that practical skills and disciplined work create opportunities that endure. Over time, these decisions began to form a pattern, one that felt less like managing assets and more like continuing a framework that had already been established. My grandfather's legacy was not defined solely by the properties he left behind, but by the way he had approached building and maintaining them. He had never treated ownership as an endpoint. It was always part of an ongoing process, one that required attention, patience, and a willingness to act when necessary without being driven by impulse. Adopting that approach in my own life required a shift in perspective. It meant viewing the properties not as personal rewards but as responsibilities that needed to be carried forward with the same clarity that had shaped their creation. There were moments, particularly in the early months, when the connection between those responsibilities and the events that had preceded them felt difficult to reconcile. The lawsuit had cast a shadow over the inheritance, framing it in terms of conflict rather than continuity. But as time passed, that framing lost its hold. The daily realities of maintaining the properties, of making decisions that affected their condition and function, gradually replaced the narrative of dispute with something more grounded. The focus shifted from what had been contested to what needed to be sustained. In that sense, the resolution of the story was not a single moment but an ongoing process. It existed in the routines that developed around the properties, in the choices made without urgency but with intention, in the quiet acknowledgement that what had been left to me carried expectations that extended beyond legal ownership. My grandfather had not been a man who explained his decisions in emotional terms, but his actions had always been consistent with a set of principles that valued clarity, resilience, and stewardship. Living with the results of those decisions meant engaging with those principles directly, not as abstract ideas, but as practical guides for how to move forward. The distance within my family remained unchanged by time in any significant way, but it became less central to how I understood the legacy I had received. What endured was not the conflict but the structure that existed before it, the framework my grandfather had built through decades of deliberate effort. That framework did not require validation from others to remain intact. It required only that it be maintained, that the responsibilities it carried be met with the same consistency that had defined its origin. In the end, what I inherited was not just property but a way of thinking, a method of approaching decisions that prioritized substance over appearance and long-term stability over immediate satisfaction. Honoring that inheritance did not involve preserving everything exactly as it had been, nor did it require transforming it into something entirely new. It required understanding what had been built, recognizing why it had been built that way, and continuing it with the same attention to detail and respect for process that had shaped it from the beginning. That, more than any legal victory, became the true resolution of the story.